Remember how confident the Hindu side was ahead of the verdict, and this in fact is a massive vindication. The court has ruled that their plea is maintainable. A petition in fact was filed by 5 women who demanded right to pray in the Shringar Gauri complex, which is within the premise of the Kashi Vishwanath temple. The court has ruled that that particular plea is maintainable. It has also in the detailed order mentioned how the defendant has failed to prove that this particular plea was barred by either the Worship Act, the Waqf Act or the Kashi Vishwanath Act. We have guests joining us on the broadcast. Namit Saxena, advocate from Supreme Court; Vijay Shankar Tiwari, spokesperson of the VHP; Gargi Nandi Roy, political analyst; Tausif Ahmed, an advocate; Syed Masood Ul Hasan, former vice president of AMU; and IP Singh, spokesperson of the Samajwadi Party, are all joining us. Let's first go across to Namit Saxena to understand the importance in terms of the order, which very clearly now mentions that the defendant, and I am repeating this, the defendant failed to prove to the court that this plea was barred by the Worship Act, the Waqf Act or the Kashi Vishwanath Act. What does that mean, sir?
See, what the trial court has held today is that there was this application filed under Order 7 Rule 11 saying that this is barred by 3 laws, which, as you said, these 3 laws, it is barred by these 3 laws. But the trial court says it is not barred by any of these laws. The burden, was on the defendants to prove that the plaintiff is barred by these 3 particular laws, and they have failed to discharge their burden. Now, after hearing both the sides, the trial court has reached a conclusion saying that this is not barred by any of the laws. Therefore, this application under Order 7 Rule 11 fails, which is titled as rejection of the plaintiff, which goes into the survival of the suit. So therefore, they have said that the suit survives. The plaint, filed by the plaintiffs is maintainable, and therefore the trial will go on. This is what primarily the court has held today, and this is extremely important because if it would have gone against the plaintiffs, the suit would have been rejected. The plaint would have been rejected. The plaintiffs would have lost their case at this stage itself. So now, because they have said this is maintainable, the suit will have to go on, the trial will go on, subject to, of course, if any appeal is filed and what the appellate courts decide. So this is extremely important at this juncture, and this is a big win for the plaintiffs in that manner.
Absolutely. Let me also bring in Tausif Ahmed. Tausif Ahmed, you are also an advocate. You understand the legal implications of this. And as many believe, this is soon going to have an impact on the other cases. The Mandir Masjid dispute cases that are pending at the court immediately could have an impact as far as the Mathura case is concerned.
You see, this Mandir Masjid case was taken up by Supreme Court, and a very large constitutional bench had delivered its judgment on the Ayodhya matter, which was treated as a closure of this sort of dispute. In that judgment, the Supreme Court observed that the Places of Worship Act explicitly ensures that the argument of mosque being a temple before would not be treated as precedent for subsequent claims of this sort. So the question is, when the Supreme Court laid down the law in the Ayodhya judgment that the question of any mosque being a temple before would not be considered because we have the Act, Places of Worship Act, then how can a lower court go against the judgment of the Supreme Court? And this kind of creates a very, puts a very circus-like question over the judicial process that we are having in India right now. There's a very well-established, documented judgment which everyone spoke about, which everyone said that this closes the dispute of Mandir Masjid. And yet we see that under the current political regime, the lower court is delivering this kind of judgment. So the question is, when in matters of faith, should a judge who comes from a one faith will ever be able to do justice? You're questioning the faith of the judge, and do you think that's interfering with the case? I want a quick counter from Namit Saxena. Is this not in the jurisdiction of the District Court of Varanasi to pursue the matter and to give the verdict that it has today? Namit Saxena? Namit Saxena, can you hear me?
I can hear you now, yes.
Yes, your quick counter to what Tausif Ahmed said.
No, I couldn't hear him properly. I'm so sorry.
Okay, I'll come back. Okay, I'll come back to you. Namit Saxena. Meanwhile, let me go across to Syed Masood Ul Hasan. He's the former vice president of AMU. Syed Masood Ul Hasan, अब कोर्ट ने ये स्पष्ट कर दिया है कि ये प्ली मेंटेनेबल है, यानी कि अब इस पर अच्छे से बहस और सुनवाई होगी. And the survey that was done by the surveyors, the report that was submitted by the assistant commissioner will all now be discussed. How do you look at this development?
कोर्ट ने बंद अल्फाज में कह दिया है कि अगली बाबरी मस्जिद ज्ञानवापी मस्जिद होगी और अगले 20 सालों के बाद ऐसी उम्मीद कर सकते हैं कि इसको भी तोड़ के यहां पर एक मंदिर बना दिया जाएगा.
देखिए, क्या होगा क्या नहीं होगा उस पर अभी से टिप्पणी करना ठीक नहीं होगा, और खासतौर पर ऐसे बयान जिससे कि लोगों की भावनाएं भड़कें. अभी तो कोर्ट ने सिर्फ मेंटेनेबिलिटी प्ली पर अपना वर्डिक्ट दिया है कि मेंटेनेबल है, इसको सुना जा सकता है, इस पर आगे सुनवाई हो सकती है. स्टे ऑन विद अस, वी हैव सम ब्रेकिंग इनपुट्स कमिंग इन. द मुस्लिम साइड हैज नाउ रिस्पॉन्डेड. द फर्स्ट रिएक्शन इज दैट दे आर गोइंग टू टेक द मैटर टू अ हायर कोर्ट आफ्टर द district court in Varanasi said that the Hindu plea as far as worshipping of Shringar Gauri is concerned is maintainable. Now a Bareli cleric has challenged that particular verdict and has said that the fight will now be taken to the High Court and will leave no stone unturned.
ज्ञानवापी मस्जिद बनारस के ताल्लुक से ज़िला कोर्ट ने जो फैसला दिया है, उस फैसले पर हमें बहुत कुछ नहीं कहना है. सिर्फ इतना कहना है कि कोर्ट का फैसला है, वो हमें मंजूर है, मगर हम इनके फैसले को आगे चैलेंज करेंगे और हाई कोर्ट में चैलेंज करेंगे, और जहां तक मुमकिन हो सकेगा मस्जिद की पैरवी में मुकम्मल तरीके से, बाज़ाब्ता तरीके से, पूरी ताकत और क़ुव्वत के साथ लड़ाई लड़ी जाएगी. कानूनी लड़ाई लड़ी जाएगी और कानून की जितनी भी कोशिशें हो सकती हैं वो तमाम ताकतों का इस्तेमाल किया जाएगा.
Let's go back to our guest, Vijay Shankar Tiwari. The Muslim side has responded and they have said that they'll take the fight to the higher court, and legally speaking उनका अधिकार है, वो ले जा सकते हैं उसको हायर कोर्ट में. विजय शंकर तिवारी, कैन यू हियर मी? आप मुझे सुन पा रहे हैं?
हाँ, देखो, हाँ, आपने जो प्रश्न किया है मैं समझ रहा हूँ, लेकिन आप इसी प्रश्न को हिंदी में अगर बात करेंगे तो ज्यादा अच्छा रहेगा.
जी विजय शंकर तिवारी जी, मैं ये कह रही हूँ कि जो पहला रिएक्शन आया है मुस्लिम पक्ष का, उनका ये कहना है कि वो इसको अब ऊंची अदालत में ले जाएंगे, हाई कोर्ट में इस मामले को ले जाएंगे. कुछ का ये भी कहना है कि ये एक गलत प्रेसिडेंट, गलत उदाहरण सेट कर रहा है ये फैसला. आप कैसे रिस्पॉन्ड करते हैं इस पर?
देखो, किसी को कोई आपत्ति होती नहीं है, और इस प्रकार के केसेस में जब भी इस प्रकार के निर्णय आते हैं तो आगे ऊपर वाली अदालत में जिसका पक्ष है उतना लेकर के जाता है. लेकिन एक बात तो आपको ध्यान में है कि झूठ के पैर नहीं होते और सत्य में जयते, ऐसी दो बातें हमारे समाज में कही जाती. अंत में सत्य की विजय होती है. हम बार बार ये कह रहे थे कि 1991 का जो एक्ट है वो इस पर लागू नहीं होता है, तो ये कह रहे थे लागू होता है, और इनके पास केवल एक आधार था, एक्ट, और उसके अलावा ये कोई बात नहीं कर रहे थे. इनके पास और कोई तथ्य नहीं है, और जब से सर्वे हुआ तब से तो इनके हाथ से सब कुछ निकल गया है. अब वो वास्तव में ज्ञानवापी वो स्थान बाबा विश्वनाथ का है, ये सारे देश को ध्यान में आ गया है. वहां की आकृतियां हैं, चाहे शिवलिंग है, चाहे वहां का स्ट्रक्चर है, स्थापत्य है, सब कुछ मंदिर का है. इसलिए अब ये आगे जा सकते हैं, इनके पास अधिकार है, लोकतंत्र है, और इससे ज्यादा मुझे कुछ नहीं कहना है.
लेकिन अभी तो जो सर्वे की बात आप कर रहे हैं और क्या वहां पर पाया गया, क्या वीडियो में दिखा, उस पर तो अभी आगे बहस होगी. ये भी सुनने में आ रहा है कि जो हिंदू पक्ष है वो एएसआई सर्वे की मांग अगली सुनवाई में, जो कि सितंबर में होगी 22 तारीख को, उसमें कर सकते हैं. ये तो खैर देखने वाली बात होगी कि आगे क्या होता है. लेकिन रिएक्शंस ले लेते हैं, और भी हमारे साथ मेहमान मौजूद है. गार्गी नंदी रॉय इज अ पॉलिटिकल एनालिस्ट. गार्गी नंदी रॉय, दिस इज बीइंग सीन एज अ मैसिव विंडिकेशन बाय द हिंदू साइड दैट द कोर्ट हैज रूल्ड दैट द प्ली इज मेंटेनेबल.
Yes, yes, Swati, because I think we have suffered such historical wrongs, and this civilization of ours is wounded. It has been wounded for thousands of years. Now, if some hope we can see, and even as per UN, if you see, even UN says countries which have been colonized, they have the right to reclaim. And let us remember, our temples are not our temples. They are history frozen in time. And Kashi Vishwanath, everybody knows it's our Jyotirling. Even our जो 12 Jyotirling का mantra है ना, उसमें भी बोलता है Varanasi from Visheshwaram. And today is a Monday. So today I think the wrongs that we have suffered for centuries, we can see some hope. And my respected panelist, another person, I could not get his name, he said after 20 years we'll say a temple there. Sir, do you agree that a temple was demolished by Aurangzeb and a mosque was built? Do your book allow that? Does Islam allow you to demolish a temple and build a mosque? Does Islam allow that? So why you should show broad mind now? You should realize that you did not come with Babur or Aurangzeb. You and we share same ancestors. Show some broadness of mind that this was a temple demolished. You people should come ahead and say, yes, a wrong has been done. Give back the temple. Okay. You should say. And Places of Worship Act does not apply here because it has a subclause which says monuments which is more than 100 years old, then the act is not applicable. And also the act itself is a draconian act brought by the Congress government. Then BJP had opposed it. So this act
Syed
should
Masood
also
Ul
be
Hasan wants to
repealed.
respond. Syed Masood Ul Hasan wants to respond.
मुझे शायद सही से सुन नहीं पाई मोहतरमा। मैं ये कहना चाहूंगा कि आप पहले मुझे सुन लेती। मैंने ये कहा कि ये कोर्ट का जो वर्डिक्ट है ये उस साजिश का हिस्सा है जिस साजिश के तहत
कोई साजिश नहीं है, कोई साजिश नहीं है।
ये साजिश है। अरे ये साजिश है,
नहीं, ये साजिश नहीं।
है, आपके बुर्गों की साजिश है, आपके जो लोग वहां बैठे
तो औरंगजेब की भी साजिश था ना, औरंगजेब ने भी तो मंदिर तोड़ा था। Isn't it documented?
तोड़ा था, आपने शायद हिस्ट्री को पढ़ा नहीं है। जाकर के पता
मैंने बहुत let me come here. I challenge you. I will challenge you.
Let him finish his point.
I have
finish his point. Garginandi Royal, come to you for a counter. बोलने दीजिए उनको पहले.
And listen to me.
Tell me.
Listen to me first. आप कह रही थी कि बाबरी वो जो ज्ञानवापी मस्जिद में जो फव्वारे का बेस है वो काशी विश्वनाथ ज्योतिर्लिंग है। तो काशी विश्वनाथ मंदिर में जो शिवलिंग रखा हुआ है वो क्या है फिर? जरा इस बात
को आपको भी पता है कि रानी अहिल्याबाई ने वो बनाया हुआ है। Let me, do you accept that the temple was demolished? It is historically documented.
वो ज्योतिर्लिंग नहीं है फिर इसका मतलब? आप ये कहना चाह रही हैं?
एक सेकेंड, देखिए हमारे नॉर्थ इंडिया में the invaders have broken so many temples. Let me tell you, sir, let me say that it is historically documented. In Aurangzeb's court there was one person called Saki Mustad Khan, and Saki Mustad Khan was appointed to maintain the developments of the kingdom and the court. So he had written one thing called Masiri Alamgiri, which had chronicled all the development from the year 1668 to 1707, and that was translated by Jodunath Sarkar, who learned Farsi, but the Congress government did not let that history book to come out. And Jodunath Sarkar had said,
मंदिर के लिए औरंगजेब ने जागीर दान करी थी 8 गांवों की, पता है आपको?
भाई साहब, it is documented in Masiri Alamgiri. Jodunath Sarkar has, नहीं, Masiri Alamgiri clearly says, which Jodunath Sarkar says that Aurangzeb said the priests in Benares are teaching false books meant of Hinduism, and they should be raised. I will read you out. Shati, give me 30 seconds. I'll read out from Jodunath Sarkar's portion, which was translated from Masiri Alamgiri. I knew this will come. I have got it. I will read the Jodunath Sarkar's portion. Give me a second, please.
Yes, meanwhile.
No, please
while you look for that.
Translation, because in translation, what your
Masood Ul Hasan, you asked her a question. You asked her a question. She's responding. सुन लीजिए थोड़ा.
I said that Jodunath Sarkar said that Aurangzeb had asked to raise temples as false books were taught, and what does he translate it from Masiri Alamgiri? I'll say the Lord Cherisher of the faith learned that in the province of Tata, Multan, and especially at Benares, the Brahmin misbelievers used to teach their false books in their established school.
Okay, we've lost your audio, Garginandi Roy. Okay, it's through.
Both Hindu and Muslim used to come from great distances to these misguided men in order to acquire this vile learning. His Majesty, eager to establish Islam, issued orders to the governors of all the provinces to demolish the schools and temples of the infidels. This is translation by Jodunath Sarkar from Masiri Alamgiri. I am not quoting from air. I am quoting Jodunath Sarkar's translation of Masiri Alamgiri, written by court chronicler of Aurangzeb's court, Saki Mustad Khan, who chronicled the happenings from 1668 to 1707. So it is established that a temple was demolished, and can't you see the structure, sir?
Also during the hearing, when the hearing takes place, ये सारी बातें मसूदुल हसन साहब आएंगी हियरिंग के दौरान कि कब डेमोलिशन हुआ, उसके बाद मस्जिद कब बना, और इतने सालों में कई बार दरअसल मंदिर को तोड़ा गया, बनाया गया। आईपी सिंह जी हमारे साथ हैं। आईपी सिंह इज ऑल्सो विद अस। आईपी सिंह, आप बहुत देर से इस पूरी बहस को सुन रहे हैं, आप क्या पक्ष रखते हैं, आपका क्या स्टैंड है इस पूरे मुद्दे पर?
आप देखिए ना, किसको स्पेस दे रही हैं, किसको समय दे रही हैं। देश संविधान से चलता है, और जो हमारा कॉन्स्टिट्यूशन है
वो सबको बोलने का अधिकार देता है।
उसको अब मुझे बोल लेने दीजिए 2 मिनट। ऐसे आग लगाने वाले लोगों को आप समय दे रही हैं।
आग कौन लगा रहा है? वो
प्रधानमंत्री का कॉन्स्टिट्यूएंसी है। पीएमओ ने मीडिया सेलिब्रेशन को कहा है, तो मीडिया सेलिब्रेशन चल रहा है। अरे भाई, लोअर कोर्ट का ये जजमेंट है, लोअर कोर्ट का जजमेंट है, अभी हाई कोर्ट है, सुप्रीम कोर्ट है। 91 का अभी भी जो कॉन्स्टिट्यूशन अमेंडमेंट हुआ, जो बातें हुई, वो सब पब्लिक डोमेन में है, हर व्यक्ति को मालूम है। क्या होने वाला इससे, क्या हो जाएगा? ये सेलिब्रेशन, मीडिया सेलिब्रेशन क्यों हो रहा है?
मीडिया में बात भी नहीं हो सकती क्या?
सेलिब्रेशन
आईपी सिंह जी, मीडिया में बात भी नहीं हो सकती क्या?
वाले लोग स्टूडियो में बैठकर
क्या है ये बताना सेलिब्रेशन नहीं है।
लोअर कोर्ट, दिस जजमेंट फ्रॉम लोअर कोर्ट, लोअर कोर्ट
क्या सबको पता है कि डिस्ट्रिक्ट कोर्ट में, सबको पता है कि डिस्ट्रिक्ट कोर्ट का ये फैसला है। आईपी सिंह जी को ये नहीं कह रहा है कि आगे ऊंची अदालत में नहीं जा सकता।
ये जो गोदी मीडिया है उसको माहौल बना रही है।
आप एक अलग ही ट्रैक पर चल रहे हैं, आप अलग ही ट्रैक पर चल रहे हैं। यानी कि डिस्ट्रिक्ट कोर्ट अगर कुछ कहे तो उसके बारे में बात भी मत कीजिए, कोई चर्चा भी मत कीजिए। अभी मामला तो वाराणसी की डिस्ट्रिक्ट कोर्ट ही देख रही है ना। अभी मामला कौन देख रहा है? अभी ये जो डेवलपमेंट हुआ है कहाँ हुआ है?
इलाहाबाद हाई कोर्ट है,
बिल्कुल है, उसके ऊपर सुप्रीम कोर्ट है, उसके ऊपर सुप्रीम कोर्ट है, बिल्कुल है। तो किसने रोका?
धर्म को लेकर
तो वहां जाने से कोई किसी को रोक तो नहीं रहा है। तो you're just trying to derail the debate. आईपी सिंह जी, आप सिर्फ बहस को भटका रहे हैं, बहस को आप सिर्फ भटका रहे हैं। कोई ये नहीं कह रहा है कि आप ऊंची अदालत में नहीं जा सकते। तौसीफ अहमद, nobody is saying that the other side, which is not satisfied with the district court's verdict, cannot approach the higher court. That's not the point. What we are discussing today is what the court has said, and is discussing the detailed order of the court a celebration?
No, I have referred to the Supreme Court judgment in Ayodhya matter, where the court said that the excuse that a particular mosque was a temple before will no more be entertained, and the act is the guarantee act. By act I mean Places of Worship Act is a guarantee that no more such plea would be entertained in future, and that the Babri Masjid will be treated as a closer. Now, this was said not very long ago, just a couple of years ago, by the top court of the country.
Okay.
In spite of the judgment, we are seeing that the lower court is passing an order, and it's not the first time. Even the inspection order to inspect the Wazu Khana was given illegally. The other side was not informed and was not given a hearing, and the order was passed. So these illegal orders are passed by lower court, and I'm asking a very fundamental question. That where a matter of faith is concerned, should the judge, who is an interested party by being a follower of a particular faith, is going to give justice? Because a very fundamental principle of law.
Is that how judges are appointed in the court? The judges have to deal with all sorts of issues that come in front of their bench. Is that how the judges are appointed? If you're a Hindu, you will not be appointed. If you're a Muslim, you can't preside over a particular matter until and unless the judge themselves recuse from the case. That's a different story. But is that the basis of appointing judges to higher courts? Tawseef Ahmed, stay on with us. I'll take that question to Namit Saxena. But we have a reaction coming in from the UP Deputy Chief Minister. The UP Deputy Chief Minister lauds the verdict of the District Court. Brajesh Pathak says that they respect the court's order.
के निर्णय का सम्मान करते हैं, स्वागत करते हैं और उत्तर प्रदेश और देश में बहुत लोग आज प्रसन्न हैं। माननीय न्यायालय के निर्णय का इंतजार सब लोग कर रहे थे और मुझे लगता है कि हमारी जिम्मेदारी है कि उत्तर प्रदेश में हम कानून का राज स्थापित करें और हर स्थिति में उसे हम कायम रखेंगे और लोगों की भावनाएं बहुत खुश हैं। मेरे पास सैकड़ों फ़ोन कॉल्स आ रहे हैं, सबका कहना है कि माननीय न्यायालय ने बहुत अच्छा निर्णय दिया। ये सब्जेक्ट माननीय न्यायालय का है, लेकिन हम सब माननीय न्यायालय के निर्णय का सम्मान करते हैं, स्वागत करते हैं और लोगों की भावनाओं के अनुरूप निर्णय है और इसी वजह से प्रदेश में बहुत ही प्रसन्नता की लहर है।
Okay, let's in fact take that point that was raised by Tawseef Ahmed to Namit Saxena. Namit Saxena, Tawseef Ahmed says while giving the verdict in the Ram Janmabhoomi case, the court made it clear that such pleas in the future will not be entertained. So how come the district court in the Varanasi can, really give a verdict on this case? How can it admit this plea? One, he is also questioning the faith of the judges.
He raised a very, very vague, statement. He made a very vague statement saying that, that because there's a trial court, there's a high court above, there's a Supreme Court above. There's a sanctity which is to be given to the trial court's order. There's a fact-finding court. There's not an appellate court. There's a fact-finding court, the first fact-finding court rather. So, making statements on TV like this and there's a trial court and, Allahabad High Court is there, Supreme Court, this is completely baseless is one. Second, coming to, your issue that, the Ayodhya judgment says that, 1991, Act bars such pleas, etc. See, the 1991 Act itself, there's a parliamentary enactment. The enactment says that there is an exception to the plea raise that that you cannot transform that you cannot convert the religious structures into you can't transform it into another religious structure. So there is an exception carved out under if it falls under the Ancient Monuments Act, etc. So this is not something which is absolutely covered by Ram Janmabhoomi's case. In every case, every trial is to be conducted on its own facts, on its own vertical. Second, number three, questioning faith of the judges. This has become a new trend now. You lose a case, you start casting aspersions upon the judges based on whatever their statements they have made in past. Now this is coming new that you're challenging faith of the judges now just because they have taken a view as per law and facts of a particular case. This is completely baseless. Coming this from a lawyer, I don't know. This is something which is completely baseless and should be shoved off at the maximum. They should not be given any weight any further.
Right. Tawseef Ahmed, in fact, on the 20th of May, it was the Supreme Court that transferred the maintainability plea from the civil judge to the Varanasi district judge.
Yes, the Justice Chandrachud and the Justice Chandrachud himself was part of the bench which decided the Ayodhya case. And in that case, that bench held that the act is a guarantee that there will be no such plea entertained in the future. And therefore, there is a conflict. When this transfer order was passed a few months ago, there was a huge uproar. The huge uproar by the former judges, by the senior advocate, which said that that this order by the Supreme Court was creating contradiction. Its own ruling is going against its own ruling, and therefore we cannot turn our eyes. The principles of natural justice.
So one verdict, one observation is acceptable. And when it suits an individual's argument, the faith of the judge is not questioned. When it does not suit an individual's argument, the faith of the judge is also brought into the picture.